Good afternoon. My name is Lily Belanger, and I'm here to speak with you regarding an issue that was brought to my attention. It appears that the Medical Records Department is having difficulties with subpoena requests, and I'd like to share some information with you regarding that. So let's get started, and we'll discuss along the way some of the information that I've discovered that I'm hoping will help your team. So the current state is that the director of the Health Information Management team is having difficulty responding to the subpoena request for the patient health records. And part of that problem is that the facility is converting from a paper-based to an electronic health record with some health records in a hybrid format. And the process of finding and identifying the various parts of the patient record from the different sources for a subpoena request, it's not easy. It's been very time-consuming and inconsistent, and it's not documented. So they're needing a little bit of support in regards to this process. So the clinical staff at Montgomery Hospital consists of 10 multidisciplinary physicians, 3 mid-level providers, some support staff, and mental health, radiology, laboratory, and nutritional service staff as well. The problem is that we have documents on paper, documents that are scanned in, we have transcription, and we also have electronic. So it's trying to come up with a policy that will help you to manage all of these different records. And of note, I wanted to mention that when storing electronic records, you must meet certain legal standards. Choice of hardware is critical when it comes to admissibility of a duplicated record. So if there are any questions regarding this process, legal counsel should be consulted to avoid any legal consequences. Now, with a subpoena request, you want to fulfill that request during normal business hours. You want to develop a policy containing steps to take when copying records and where and how the copies will be stored. And the Medical Records Department must be aware of this policy, where it is, and what it means. In addition, the policy should state that a witness needs to be present during the time the record is copied and possibly will be asked to testify under oath that the copy matches the original. And last, the review. The policy should be reviewed routinely in order to ensure the compliance procedures are met. One thing I wanted to mention as well is that tracking the paper and electronic portions of the health record is essential. When records are transitioned from paper to electronic, dates should be documented to provide a guide for staff when retrieving the patient's health information. Now, subpoena disclosure policy, here are a few things that I wanted to mention. You need to develop and maintain inventory of documents. So any medical or billing information used to make decisions about the patient is included under the HIPAA privacy rule, regardless of whether the information is external or internal. Also, you want to declare the legal health record in an organizational policy, and you want to make sure you're following state and federal HIPAA policy rules. You want to consider a single repository for legal retention and requirements. So you want to collaborate with your IT department to define retention policies and practices. Proper retention of the EHR is critical to collecting the complete record for release. Next, you want to consider the use of records management software that will help you to manage emails and instant messages. And you also want to develop procedures for identifying external information. So when there is no state law, the organization must determine if external records will be part of the health record. Next, you want to determine how information may be released. So there's components of the legal health record must be reproducible in an accessible format. So you need to take that into consideration. Also, you want to dispose of any health information that is not used or needed. Identify information that should not be in the legal health record, like audit trails, metadata, and psychotherapy notes. Train medical record staff on procedures regarding disclosure and redisclosure of health information. That's extremely important. And identify the records that individuals have the right to access and amend under state and federal laws and regulations. So in the absence of main state law, the HIPAA privacy rule prevails. So written results of a test such as an X-ray or an EKG or other similar procedures are always part of the record. So you want to verify the record request. So first you want to verify the identity and the authority of the requestor. You can request a driver's license or a passport for that purpose. You also want to validate that the format of the request meets state legal requirements for a valid subpoena or court order. Then next comes legal power. So the patient or the legal guardian can request records by phone, fax, email, or HIPAA authorization. And legal requests can come from a lawyer, court order, subpoena, and to the proxy if the patient is deemed incompetent. And finally, with disclosure, the information should be disclosed to the intended recipient by consent of the patient or legal guardian, also by court or lawyer designated on the subpoena or court order. Admissibility of health records. Paper, computer files, erased files, and emails can be subpoenaed. You want to comply with the state time frame to meet the discovery request. Records must be prepared and maintained in accordance with the federal rules of evidence, which is in effect to ensure that certified record was in alignment of regularly conducted activity of a business. And the organization must be familiar with the policies and procedures used to ensure accuracy of the records. And finally, consult the organization's legal counsel with any questions regarding this process. You want to determine if the records can be disclosed. So first you want to the request must be HIPAA compliant and valid. Federal rules and regulations must be addressed, and there must not be a conflict with state statutes. Prior to disclosure, you want to confirm if state laws require a subpoena or court order. You want to determine if signed consent by the patient is required or if PHI needs to be concealed prior to disclosure. And you want to reference the HIPAA security rule if the information is released electronically. Safeguards must be in place if covered by the security rule. And finally, paper format is acceptable. You want to review state law to ensure other formats are not required. I attached the HIPAA privacy rule here in case you wanted to review that. So at your leisure, I will be providing the slide deck and you can review this at your leisure. And then for printing documents, I wanted to put a slide in here regarding that. There's some very specific rules around this. So the recommendation is that you want to create a policy that contains a schedule and migration process for each record, containing diagnostic reports from laboratory and radiology and transcribed reports from paper through hybrid to the EHR. The schedule must include timeframes to stop or disable printing of this information. And keep in mind when printing electronic records, a watermark or label should be used with the following information: confidential health information, instructions, for example, not to file in a patient record and not to remove from facility or use designated disposal area when finished. And then you want to document that the report has not been reviewed or authenticated if applicable. Now, here's a flow chart of how your department, your medical records department, would respond to a subpoena request. So the request would come in, and first you would want to confirm identity of the requestor and the subpoena are valid. You want to validate the format of the request, that the request meets the state and legal requirements. You want to notify patient and proceed if patient consents. You want to provide the legal medical record by copying the records in format according to policy. And keep in mind that paper, computer files, and erased files and emails are acceptable, and any medical or billing information used to make decisions about the patient is included. Next, you want to avoid providing more information than necessary to comply with the subpoena. So the subpoena will be very specific about what information they would like you to provide to them. And the paper records would be copied, the EHR records are printed, the scanned records are printed, and the cold fed documents are printed as well. That's all done by your medical records department. And you do not want to include specially protected records like mental health records, drug alcohol treatment records, psychotherapy, testing for HIV, and mental health, behavioral health, or treatment records for substance abuse. So none of that would be included in this process. If you cannot satisfy these conditions, you want to make sure that you consult legal immediately. And if the subpoena does not specify time to respond by, you want to respond after 21 days, and that ideally would be between 21 and 25. And then the medical record director confirms authenticity of the records that you're submitting for the subpoena. In summary, the HIPAA fines can be very severe, So it is of the utmost importance to only disclose the information requested in the subpoena. Contact the source issuing the subpoena to obtain written assurance and document the process. Do not include psychotherapy notes unless there is a valid court order. And finally, complete an authorization form to release the records. That is the end of my presentation. If you have any questions at all, please don't hesitate to reach out to me. And as I mentioned earlier, I will be providing these slides to you so you can reference them at any time. Thank you so much.